Thank you, Your Honor. I'd prefer to be at the podium if that's okay.
That's fine.
Your Honor, may it please the court and Mr. Tank, opposing counsel. My name is Stan Preston. I have with me Tom Johnson from the Bradshaw Fowler firm as local counsel, and Ross Blackham, who is the general counsel of Moroni Feed Company. Your Honor, I would like to start with the legal context in which the court is required to resolve these issues that are before the court. And that is a context that is highly, of course, deferential to an arbitration panel. And we've cited a lot of that case law, but just it's very clear. Courts use phrases such as any review is exceedingly deferential, judicial review is extraordinarily narrow, courts must exercise great caution when setting aside an arbitration award, severely restricted by statute, and then a party bears a very heavy burden in seeking to vacate an arbitration award. I submit that that burden is heavier when you are trying to set aside an arbitration award on the basis that the award is not reasoned. As the Fifth Circuit has stated, based on the well-established deference afforded arbitration, courts have generally been reluctant to vacate awards for failure to render a reasoned award. And there are many courts across the country, and we cite several, who say that is not a basis under the law. So that's the context in which we deal with that. I think the standard, we've cited some cases that say when you're dealing with whether a damage award is reasoned, that is even a higher standard. So let me focus for a moment on what is a reasoned award. The standard is very low. It must simply contain or mention some explanation or justification for the award. My primary argument, and I disagree with Mr. Tank's characterization of what our position is, my primary argument is that the award is reasoned. It's a 21-page award written by 3 very competent judges. They addressed all 8 of Moroni Feed's claims. They addressed each of the counterclaims in detail. They explained the method for the calculation of damages for each. And I submit that the panel's statement of the award of prejudgment interest meets this extremely low standard as to what constitutes a reasoned award. It's important that we recognize we're dealing here not with a case of future profits or a projection of profits. We are dealing here with historical transactions. It is possible, and it is established by our expert, you can calculate to the penny exactly the amount of accrual funds that West Liberty Foods generated and used. It is also based on the voluminous accounting records that are available. You can go through and look at the facts and calculate to the penny the amount of accrual funds that were generated from the sale of my client's products as opposed to Nebraska turkey growers' products. This is not a case like the cases which Mr. Tank has cited, where there is conflicting expert evidence as to how the calculation should be done. There is no conflicting testimony on this issue. Your Honor, I think if we looked at 5 cases, they will illustrate why this is a reasoned award in its entirety, and that's how courts look at it. As Mr. Tank has admitted, courts look at the entire award to see whether one portion is reasoned on those courts that allow you to look at that. The 5 cases are Cat Charter, the Carmody decision, the Leeward decision, the Range C2 chlorine LLC case, and then the Vold case. Let me start with the Cat Charter case. Both sides cite this case. In that case, the award only provided, there were a number of claims and counterclaims, and the panel said as to two of the claims that the plaintiff has proved his case by the greater weight of the evidence. That is the only explanation they offered. That's it. Then they denied all the other claims without explanation and denied all the counterclaims without explanation. Now, they sustained the claim on a misrepresentation under Florida statute, and they sustained it as to a breach of contract. There were breach of fiduciary duty claims. Now, clearly, credibility was a major issue, but when you're dealing with breach of fiduciary duty, you would expect a reasoned award as to say whether there was a duty, how the duty arose, or if there wasn't a duty, or how it was breached. There's no discussion of any of that. Now, much of that award is cited in the case, but I have also pulled the actual award, Your Honor.